Waiting for some people to connect. Okay, this is JLLJ Development LLC and Lansing Future Development LLC versus Kawaitan Casinos Gaming Authority, docket number 21-189CB. This is the time set for hearing on what is entitled the defendant's motion for summary disposition due to lack of subject matter jurisdiction. And I will take appearances for the record, please. Plaintiffs first.
Andrew Broder and Michael Perry for the plaintiffs.
Mr. Rasmussen, your appearance.
All right. Jeff Rasmussen for the Kuwait Casinos.
All right, your motion, Mr. Rasmussen, whenever you're ready.
Thank you, Your Honor. As we discussed in our motion, this court lacks subject matter jurisdiction based upon the Indian law doctrines of infringement and preemption. In our brief, we provide a detailed discussion of those doctrines, that when we are dealing with an Indian tribe, the state court doesn't have jurisdiction where that jurisdiction has been preempted by federal law, including the US Constitution and other federal laws. And it doesn't have jurisdiction where the exercise of the state court jurisdiction would infringe on the tribe's right to make its own laws applicable to its own lands. And in this particular case, as we discussed, most of these issues have already been resolved in the federal courts, that the tribe has the treaty right to be free from unwarranted state court interference, that it has the right within those treaties to be able to make its own laws and to be ruled by them. And those then bar the state court or state forums from adjudicating claims such as those in this particular case. There are a few different ways that a state court can get jurisdiction over a claim against a tribe or a tribal entity. Simply none of those apply here, because we're talking about a casino. Kuwaitan Casinos is an on-reservation entity. The plaintiffs chose to contract with Kuwaitan Casinos, and that when they did so, they were well aware that the tribe's laws regarding gaming applied. In fact, they acknowledged that in the contracts. They acknowledged that they potentially would have to have the tribe either license them or determine whether the contracts were management contracts or any of those sorts of issues. They knew that that was the law applicable. What they're trying to do is avoid now that application of that law. So in our brief, we discuss that background, and then we discuss, and those are relatively complex issues, complex legal issues regarding the scope of jurisdiction, how we divide jurisdiction between three sovereign entities. We've got tribal jurisdiction, we've got federal jurisdiction. And in this particular case, there would be, if trying to divide that line between tribal jurisdiction, federal jurisdiction is relatively more difficult. Where that line is between tribal jurisdiction and state jurisdiction is not difficult. Here, we're talking about a claims seeking all of the tribes' gaming proceeds, all of them. We're talking about claims that we have that all of the tribes' gaming properties, financial gaming documents, those sorts of things. Those are all on reservation. That's all part of why this is preempted by federal law and why the tribes' laws control this. In their response brief, the defendants argue that, well, because state courts have jurisdiction in some cases, they must have jurisdiction in this case. This is actually the easy case, because in this particular case, we are dealing with whether or not the tribes' laws regarding gaming control. And the case law says that the tribes controlling that state jurisdiction is completely preempted by the Indian Gaming Regulatory Act, and that therefore, because state law is completely preempted, there can be a dispute regarding the scope of federal jurisdiction and tribal jurisdiction, but there's no issue regarding state jurisdiction. State jurisdiction is completely preempted here. It's not just preempted, it is completely preempted here. And that then makes it, when we're talking about the doctrine of preemption, federal Indian law doctrine of preemption, this is the easy case. In this particular case, Congress has spoken, and Congress has said that this is an issue within the tribe's jurisdiction. And that, as we discussed in our brief, that arose out of case out of California, Cabazon, where the state was asserting, oh, we need to be able to do this regulation of the tribe gaming. And the US Supreme Court said, no, we understand that there's state interests here, but you don't get to do that regulation. You don't get to do that regulation of tribal gaming. Tribal forums do that. And then in response to that decision, the United States Congress weighed in. And one of the main concerns it had was unscrupulous entities like these plaintiffs who try to take advantage of tribe. And so one of the big things that the Indian Gaming Regulatory Act did was to say, if it's a management contract, it is void ab initio. This is the subsequent NIGC interpretations, but if a gaming contract requires approval, and it requires, in this particular case, the approval of the Tribes Gaming Commission, and it would require the approval of the NIGC. So that was one of the things that, other than that change, really, the Indian Gaming Regulatory Act just mostly codified the Cabazon decision. And then it gave one way that states to get jurisdiction over tribal gaming. And it said, if you enter into a compact that gives you that jurisdiction, then you can have, if the tribes in the state agree to that, then you can have it. But otherwise, the state jurisdiction is preempted. And here, as we discussed, not only did the state of Michigan not for authority over tribal gaming, it expressly agreed in its compact that the tribe had that jurisdiction. The tribe's gaming laws apply. Now, in their brief, the plaintiffs rather say the NIGC, and they say the federal courts, although I don't even know what they're talking about there, but the NIGC held that these were not gaming compacts or gaming management contracts. That is simply not correct. What the NIGC said was, based upon the tribe's statement of what it understood the contracts to be, these would not be gaming management contracts. But if you look at the tribe's letters that have been submitted to the court, that the tribe submitted to the NIGC, virtually every provision in there, virtually everything the tribe said about these contracts, the plaintiffs now disagree with. They assert they have all sorts of powers that the tribe said they didn't have. The NIGC then said, okay, under what we've got here, based upon what the tribe has submitted, this wouldn't be a gaming management contract. But based upon what we know now, because the developers have just vastly overreached in this case, that they don't understand the law, they don't understand the limitations, and it would have been very, very difficult for them to bring a claim that didn't violate that. But they've just vastly overreached here. They're asserting that they have the right to fire the tribe's key employees in their gaming operation. That's one of their claims. They assert they have the right to, the tribe, or rather Kuwaitan, violated the contracts because Kuwaitan decided to appeal, or because the tribe actually decided to appeal, a federal court decision related to the downstate properties. They assert that they get to make, they have veto power over the tribe's budgeting decisions and the Gaming Commission's budgeting decisions. Those are the hallmarks of gaming management. And their overreach is what's gotten them into this problem. So now that they're disavowing everything that the tribe said to the NIGC's statement, oh, we don't believe we have to approve these contracts, that's no longer of any import. If in Casino Magic, rather, a 8th Circuit case, this was one of the issues because the plaintiff, in that particular case, just a second, sorry, I had the citation up here. United States versus, or it's actually United States ex rel Bernard versus Casino Magic Corporation, 293 F 3rd 419, 8th Circuit decision from 2002. In that particular case, the case was brought as a qui tam action by a party. So it was asserting that it stepped into the shoes of the United States, and it asserted that Casino Magic's contract was a void management contract. And Casino Magic said, well, look, here's our declination letter from the NIGC. They said that it wasn't. And the 8th Circuit said, yeah, that's all fine and good, but now that with what we've gotten later, these other related documents that we can look at, we now realize that it wasn't a gaming management contract. So the NIGC then came back and said, it is a gaming management contract. Because their declination letter is just a letter based upon what was submitted at the time. If the developers had stuck with what was submitted at the time, they might have an argument, but they didn't. Instead, they came into this court and they told this court they have the power under the contracts to fire tribal employees, gaming employees, to control the gaming budget, to decide whether the tribe appeals decisions, all those sorts of things that are quintessential management functions. So it's because of that overreach that they are now dead in the water. There is no way this court can now exercise jurisdiction over this case because of their overreach, their mistake. So when we talk then about complete preemption, the IGRA completely preempts state court jurisdiction. What it also does is provide the Tribal Gaming Commission with the authority to determine whether this was a casino management contract. And We presented that issue to the tribe's gaming commission. And the tribe's gaming commission determined, rather obviously, because of the vast overreach here, this isn't even a closed case anymore, that it was a gaming management contract. So the core of the plaintiff's response to our argument in this case is to offensively assert that the tribe's gaming commission is some sort of a corrupt entity. They refer to that proceeding as a sham. That is not acceptable. That is not acceptable behavior by an attorney to use words like that to refer to some other law-applying forum. If they were doing that to any other law-applying forum, this court would not tolerate it. But that is their counter-argument to the motion today, is wholly dependent upon their assertion that the gaming commission, the tribe's gaming commission, its proceeding was a sham, and therefore this court can ignore it. There are so many problems with that argument. And as we discuss in our reply brief, we only have 5 pages, but as we discuss in our reply brief, first of all, this court doesn't sit in as the appellate body for the tribe's gaming commission. There may be, potentially could be a claim in the federal court, but this court doesn't sit in review of the tribe's gaming commission decision. It just doesn't. Second, their allegation of bias is wholly insufficient. It is not inappropriate for a gaming commission, people on a gaming commission, to wear multiple hats. It is not inappropriate for people on a public utility commission to wear multiple hats. Often, these commissions do have investigative and adjudicatory functions. And then I think also dispositive is they chose not to appear. They chose not to appear at the gaming commission decision, proceeding. And their attempt to get around that is beyond the pale. They have Mr. Campbell sign an affidavit that is vague about when he received some document from the corporation that he's a member of. And obviously when he received documents is immaterial. But then their attorneys assert as fact to this court that they did not receive the notice of hearing. That was simply false. This isn't the first time they've made false allegations under oath or made false allegations to this court. We provided the documents from the process server, a neutral process server, that showed that they did receive the notice. They chose not to appear, and they defaulted on the allegations. And now they want to come into this court and say, this court should decide whether the gaming commissioners should have recused themselves under the tribe's laws, or whether something else should have, whether the decision was right under the tribe's laws. Those are not issues that this court decides. They probably aren't issues that any court decides at this point, because the developers chose to default on the tribal court or the tribal gaming commission proceeding. So we have the decision from the entity that has the sole power to make this determination under the tribe's laws. And as we discussed, the tribe's interpretation of its own laws is binding in this court, just as the Michigan Supreme Court's decision on Michigan law would be binding in a different court, including in the US Supreme Court. That's what we are talking about when we're talking about different sovereigns. The tribe gets to make this decision, and the tribe issued its decision. And if these particular plaintiffs want to disagree with that, then they should have gone into the tribal forum and they should have made their arguments there. Now, in this particular case, the tribe's gaming commission is, for legal analysis purposes, the tribal court, because an Indian tribe doesn't have to have 3 separate branches of government, and many of them do not have 3 separate branches of government. And so what we've got with this tribe is that the power, the judicial power, there's not a separation of powers within the Constitution. The judicial power remains with the tribe's executive branch, and it can delegate that power, and it has delegated a lot of that power to the Sault Ste. Marie Tribal Court, but it has retained some of the power to itself, and it has delegated some of that power to the Tribe's Gaming Commission. That is perfectly acceptable. So, in fact, in the case law that discusses a tribe's authority, the references are then to a tribe's court or other law applying forum. And so we've got a decision from the tribe's law applying forum, equivalent to the tribal court. Defendants or respondents in that tribal matter decided not to appear. And now they want this court to review that decision, and this court simply doesn't want to do that. Wanted to cite one other case to this court, which is United States versus Missouri, Mazure, 419 U.S. 544, 1975 case. In that particular case, the Supreme Court is discussing, we've got a tribal council. So the tribe's executive, chief executive, head of its executive, the tribe's council decided not to approve somebody for a license. And that person then brought a federal court suit, and notably it's federal court suit, not state court suit, because we don't go through state court on any of these issues, but brought a federal court suit and is saying, well, look, the tribe's board, or its chief executive branch, its council here, in that particular case, it was called the tribal council. The tribal council can't make these types of decisions. And the Supreme Court said, no, this is a tribal law applying forum, it can make these decisions. Then they said, well, you can't, Congress can't have delegated this power to the tribe. And the court said, no, Congress has plenary power. If it chose to do that, that is fine. That is within its power. And so these non-Indians who wanted to have a license were denied the license by the tribe. They didn't have a federal path for appeal. Any attempt at federal path for appeal would violate infringement and preemption. And in that case, the court also noted that, like in this case, the law in that particular case was a law that had to be approved by the United States prior to it being enforceable by the tribe. And we have the same thing with the tribe's gaming laws. The tribe's gaming laws were approved by the NIGC. The tribe was exercising power within those laws as approved by the NIGC. The Indian Gaming Regulatory Act also affirms that this is something the tribes make this decision. So when we're talking in this particular court about jurisdiction, this is the easy case, because this court does not have jurisdiction to disagree with the tribe's decision. If the plaintiffs want to do something to dispute that decision, they first of all should have appeared in the tribal proceedings, but they chose not to. They second of all should have done a motion to reconsider, which was permitted, but they chose not to. Instead, they want to come to this court and have this court overturn the Gaming Commission decision or say, I'm going to not recognize that. So what we've got is a tribal decision that says these contracts are void ab initio. And this is the standard remedy for this type of unscrupulous behavior by these types of plaintiffs. The risk is very extreme. And I'm going to point back to the Casino Magic case, because in that case, the gaming developer had invested millions of dollars of money and had received a bunch of money from the tribe, rather. It had received a bunch of money from the tribe, and the case was a qui tam action. And what the plaintiffs in that case, so the United States was seeking in that case, was not just to say the contract was void ab initio, which it was, and that was the whole, but also that they had to return every single penny that they obtained from the tribe because the contract was void ab initio. The consequences are very large. And we cite to the NIGC bulletin that discusses that, discusses the extreme risk that somebody is taking when they make the type of arguments that these plaintiffs have chosen to make in this court, when they assert that they have the right to manage the tribe's casino, not only in the past, but into the future. So then the only other option they would have would be to go into federal, both this court through its attorney in the federal court, and the plaintiffs themselves are asserting the federal court doesn't have jurisdiction. I think they'll quickly realize that that's probably a mistake and change their tune on that. But their path, if they don't agree with the Gaming Commission decision, is to proceed with the appropriate remedies with regard to that entity that has the complete jurisdiction to determine these contracts were void. Now that we know the contracts were void ab initio as a matter of dispositive law, this court does not have jurisdiction. It simply does not. We don't get to the alleged waiver of sovereign immunity because it is void. That's the API case that we cited to the court. We don't get to exhaustion because their contract was void ab initio. So again, that's also the API, the attorney's process and investigation case. When the contract is void ab initio, then the provisions in it are not of any import. So under both that API case that we cited, also under casino management, under other cases, we can't bootstrap, as the plaintiffs are trying to do, in order to say that the contract terms somehow prevent or give this court jurisdiction when the contract is void. If they didn't want the contract void, they shouldn't have made the outlandish arguments for power to hire and fire tribal employees, to control the tribe's gaming budget, to decide whether the tribe appeals a decision, to control the casino budget, any of those things. Those are their claims here, and therefore
I've given you 30 minutes, so you'll have to wrap it up, please, Mr. Rasmussen.
So that's where we are right now. We've got a contract that is void, and this court then is required to hold that it doesn't have jurisdiction. And if they want to dispute the Tribal Gaming Commission decision, they should do that through the appropriate methods. Thank you.
Thank you. Mr. Broder?
Yes, thank you, Your Honor. Mr. Rasmussen, as you noted, took about 30 minutes. I plan to take about 3 minutes. Let me say to Your Honor that the position of Kuwaitan here is based on the wrong court rule, the wrong law, on wrongly asserted principles, which are flatly inconsistent with positions it's taken in this court and in federal court. And finally, on this wrongful and what I would think is utterly shameful reliance on the antics and actions of the Gaming Commission. It seems to me, Your Honor, that a challenge to this court's subject matter jurisdiction should have been brought under 2.116C4, but Kuwaitan didn't do that. A challenge to this court's subject matter jurisdiction should have dealt with the broad jurisdictional authority given to the circuit courts of this state under the Michigan's Constitution, and on the many Michigan decisions, appellate court decisions, Bates, Star Theaters, and the others cited in our brief, which recognize that jurisdiction in cases like this. But Kuwaitan didn't deal with those issues. They just ignored them. And instead, Kuwaitan relies on this narrow line of 10th Circuit decisions, which don't bind this court and are readily distinguishable because those decisions deal with actions on reservation property. But the most outrageous of all is this reliance on the Gaming Commission. I stated in our brief that it was probably the most outrageous claim I guess this court probably would have ever seen. When you think about it, even Mr. Rasmussen admitted today that the folks on the commission wear the same hats as the folks on the tribe in Kuwaitan. But let's think about that. Aaron Payment is chairman of the board of the tribe, well, at least until a couple of days ago when he resigned. He was chairman of the board of the commission. He was chairman of the board of the casino. The other cronies of Payment on the commission also are board members and are involved with the casino and the tribe. So what Kuwaitan has the audacity to tell this court is that we can be litigating the development agreements in this court for the last year. We can be litigating those agreements in federal court for the last 2.5 years. And as soon as Kuwaitan doesn't like the rulings of those courts, it can simply tell its own members to put on their gaming commission hats, void the contracts, and permit Kuwaitan to come into this court and the federal court and say, gee, too bad, but these contracts that we've all been discussing, which this court has looked at the language carefully to determine that sovereign immunity was waived, and which, as we pointed out in our brief in response to this summary disposition motion, also includes an explicit consent to jurisdiction. Kuwaitan says to this court, forget all that, because we can, on our own, using our own people, simply turn around and void that contract, and there's nothing anybody can do about it. Well, that is beyond drivel. That, in my mind, is a violation of the Michigan rules of professional conduct and the requirements of those rules that govern what attorneys have the right to say and not say in courts of law. And I would also say, to your honor, in really almost in closing, that, as you know, the development agreements include, as in addition to the consent to jurisdiction and waiver of sovereign immunity, that Kuwaitan explicitly agreed not to resort to any tribal forums or courts while jurisdiction existed here. So they've violated their own agreements, and then through this sleight of hand, they think that they can magically turn around and tell this court, well, we had our own people void this agreement, so we're all stuck, goodbye. It doesn't work that way. You know, in closing, I want to say, to your honor, that Kuwaitan has asked the federal court to halt these proceedings, and the federal court declined to do so. Kuwaitan has asked the Michigan Court of Appeals, twice even, to halt these proceedings, and the Michigan Court of Appeals declined to do so. It's time for the court to deny this motion for summary disposition and let us go to trial on damages. Thank you, Judge.
Mr. Rasmussen, you can have 5 minutes for rebuttal if you would like.
Thank you. Thank you, Your Honor. Mr. Broder's argument is beyond the pale. That is not appropriate to be making arguments like that. You don't refer to members of a foreign government as being told what to do and being cronies and things like that. The open appeal to those sorts of arguments is all they have left, because they don't have a legal argument here. You notice that he didn't say at all, oh, we're not asserting any of those management authorities. We are. It's in the court record in this case, all over the place, that they are asserting those powers. It is in their complaint. It is in their motions for discovery, that they are asserting the power to manage the tribe's gaming operation in perpetuity, practically. So what he doesn't say is that. Instead, he goes after the judges, the tribal court judges, and calls them names. If I did that in a court, I would be held in contempt. I don't appreciate them using those types of words to describe the proceedings. They chose not to appear, and this court doesn't review that. That is the issue here. And they don't have a single responsive argument other than to call names. The Tribal Gaming Commission issued its decision. It has the power to do that. They don't dispute it. The Tribal Gaming Commission has the power to declare the contracts void ab initio. They don't dispute it. Instead, they attack the decision makers. But they don't even attack the decision makers as their decision was wrong. They just attack the decision makers themselves, because their decision was plainly right. This was obviously a management contract as they now interpret it. This isn't even the close case. So he can call people names all he wants, but that is not a basis for this court to exercise jurisdiction over this case. This, as we say, this was plainly a management contract. That was the holding. If they want to disagree with it, they should adopt the appropriate procedures. This court has to respect the decision of another sovereign. And in fact, the Michigan court rules provide just for that. But full faith and credit for the tribal court decision, for the tribal decision here. Full faith and credit. That's the Michigan court rule. So here, what we have is an appeal that, oh, they're just a bunch of corrupt people, and therefore this court should say it's not going to grant full faith and credit. But that's not the law in this state. This court has to accord the tribal decision full faith and credit. It is the final decision from the court, from the highest body within the tribe with jurisdiction over this issue. It is a final decision of the tribe. It is a final interpretation of their laws. And if they want to go back to the tribal forum and seek some further review, they are welcome to do that. But right now, what this court has is the final decision from the tribe's highest law applying forum on this particular issue, and mere allegations of corruption are not sufficient to overcome that. They don't dispute that the tribe had the jurisdiction to issue the decision, because they can't, because we say this was state law, federal law, tribal law, all agree the tribe not only had the jurisdiction to issue it, but had the exclusive jurisdiction to issue it. So we've got a decision from the highest body that has jurisdiction, and name calling is not a basis for state court jurisdiction over this case. So we would ask the court to dismiss this because the contract is void ab initio, and to then let the plaintiffs know that if they want to go to the tribal forum and do their name calling there, they're welcome to do it, but it's not appropriate in this court. This court should not tolerate it.
All right, thank you. First of all, this is the defendant's motion for summary disposition labeled as being brought under MCR 2.116C10. It does raise subject matter jurisdiction, and it is more correctly labeled as being brought under MCR 2.116C4, and I will consider it under 2.116C4. The defendant asserts that this court, or any state court for that matter, has no jurisdiction over Indian tribes who are self-governing communities with exclusive authority within the reservation boundaries, free of state court's infringement on their authority. While those may indeed all be true and accurate statements about the autonomy of Indian tribes and the law as it pertains to their self-governance, it does not mean that in the exercise of their self-governance, they cannot agree to waive sovereign immunity, sign contracts that are to be governed by and interpreted in accordance with the laws of the state of Michigan, agree to submit to the jurisdiction of the state of Michigan courts, and agree to waive exhaustion of tribal remedies. They did all of that in this case, as I have previously ruled now almost a year ago. Furthermore, this case does not involve any claim arising within the reservation boundaries. This court is exercising subject matter jurisdiction over a contractual dispute arising out of funds advanced by non-Indian plaintiffs to the Kawaitan Casinos Gaming Authority for the development, financing, and construction of a casino on land in Lansing and Wayne County, hundreds of miles away from the tribe's headquarters and not within the reservation boundaries. For the same reason, and that reason being that this is not a dispute that occurred or arose within the reservation boundaries, there does not have to be a special election where the tribe consents to state court jurisdiction, and 25 USC section 1322 does not apply. I do not necessarily disagree with, I have no argument with the law that is cited in the defendant's brief. The problem that I have with it is that that law is inapplicable here. It is inapplicable here where sovereign immunity was waived. There has been consent to the jurisdiction of the state court. This dispute did not arise within the reservation boundaries. This has nothing to do with management of tribal gaming activities. This is a contract dispute falling under the general jurisdiction of this constitutionally empowered court. And as I back up a little bit and say this has nothing to do with management of tribal gaming activities, that has been very much in contention here today in the argument of counsel. In fact, the court had previously, when ruling almost a year ago, reviewed the contracts and concluded and concludes now that these contracts do not have to do with management of tribal gaming activities. I am not the only court that made that conclusion. When the case was originally filed in the federal court, the federal judge made the same observation, saying to the contrary, the developers and the gaming authority expressly decided not to enter into a management contract. Instead, the gaming authority maintained the sole and exclusive authority to operate, manage, and maintain the gaming facility. The judge went on to say, the claims in this case do not attack the tribe's licensing process or interfere with the tribe's ability to regulate gaming on tribal land. The developers did not have to obtain any license from the tribe, nor did the developers enter into a management agreement with the tribe. The claims in this case represent a standard contract dispute and are far removed from any attempt to regulate tribal gaming on tribal land. Having reviewed the contracts, I agree with the federal judge, and I so find. The issues that are raised by the defendant, for the most part in the defendant's brief, ignores all of this court's previous rulings, which are in fact dispositive of the issues that are raised in this motion regarding subject matter jurisdiction, with the exception of now this ruling of the Gaming Commission, which I will very briefly address, because now at this point, finally, the defendants have recently obtained an order from the Sault Ste. Marie Tribe of Chippewa Indians Gaming Commission, declaring that the development agreements in this case are void ab initio. To the defendants, this means that the waiver of sovereign immunity, the agreement that the development agreements be interpreted in accordance with the laws of the state of Michigan, the agreement to submit to the jurisdiction of the state of Michigan courts, and the waiver of exhaustion of tribal remedies have all been voided. And to the defendants, this means that this court is bound by the commission's order the same way that this court must follow decisions of the Michigan Supreme Court. I must agree with the plaintiffs that these propositions are absurd to the level of being breathtakingly absurd. I will not even address the due process issues, but essentially the defendants maintain that essentially the same body, or mostly the same body that makes up the defendant's authority in this case, has unilaterally declared, after this court has ruled that the contracts in fact contain waivers of sovereign immunity, agreements to be bound by the laws of the state courts, that they somehow can, after the fact, come along and unilaterally declare their own contract to be void ab initio. And to say that this court then has to abide by that and is bound by it, there are no words to describe on these facts with the language in the contracts that the court has already ruled on. There's no words to describe the breathtaking absurdity of such an argument. There is no authority for this argument, and I will not address it further other than to say that I wholeheartedly reject the argument that the Gaming Commission can come along and at this stage declare that the contracts are void ab initio, and that this court has to follow the finding of the Gaming Commission. I have already given my reasons why I reject the defendant's motion for summary disposition as to subject matter jurisdiction. Most of it goes back to the ruling that I've already made about waivers of sovereign immunity, waivers of tribal court jurisdiction, and I am denying the defendant's motion for summary disposition, and that would be under MCR 2.116C4. And I'll ask you, Mr. Broder, to prepare an order that states for the reasons stated on the record and submit it under the 7-day rule.
I will do so, Your Honor.
All right, that will conclude our hearing.
Your Honor, may I ask a question? We have a trial date on May 31. We adjourned the pretrial conference because of the pendency of this motion. And for planning purposes, we wondered what the court's pleasure was going forward.
Well, I can tell you, having nothing to do with the procedural posture of this case, I have another case that's older that is set on May 31st, and it is certain to go. We have settled jury instructions. We have really finalized everything. I know it's often, civil cases often settle, but we've gone so far on that case that I am really confident that it is a date certain and it is going to trial, and it is older than this case and has priority. So
Okay.
We will have to, we can either, you can either stipulate to a new trial date if you wish, or I can ask the assignment clerk to send out a new notice, just as he would anytime that the cases that are farther down on the docket get bumped by an older case that goes to trial, and he sends out a new trial notice. So maybe that's the best course of action.
Okay, thank you.